You just received a formal legal demand letter from a Vietnamese law firm. The instinct is either to panic or to ignore it. Both reactions can be costly. A demand letter is not a court order, but it is a clear signal. The sender believes a breach has occurred and is willing to escalate. If you respond poorly, you may damage your legal position. If you stay passive, you may lose leverage and time. In this video, we explain how to respond when your company receives a demand letter in Vietnam, so you protect your rights, manage risk, and stay in control of the next step. A demand letter is a formal notice that sets out a claim, a deadline, and a proposed path forward. It often comes before litigation or arbitration, and it is usually written to create a clear record of notice and a clear timeline. It may also reflect a strategic goal, to trigger settlement before formal proceedings begin. That is why you should read it as a business and legal signal, not as a final verdict. The best mindset is simple. This is an opportunity to assess exposure early, correct misunderstandings, and resolve the matter on terms you can shape, before the process becomes public and procedural. Do not reply immediately from emotion. Avoid denial, accusations, or informal explanations sent by sales staff or operations teams. Messages, even short ones, can later be used as evidence, and a rushed response may unintentionally admit facts you cannot support. Instead, acknowledge receipt internally, preserve the letter and attachments, and assign a single point of contact. Then move to structured review. Speed matters, but accuracy matters more. Your next step is a disciplined check of the contract and the timeline. What does the contract say about payment, delivery, acceptance, penalties or interest, and dispute resolution? Are there notice requirements or cure periods? Is the claimed amount calculated correctly? Do you have defenses such as non-conforming goods, delayed delivery, incomplete performance, set off, or an agreed variation that was not documented properly? This is where many companies make expensive mistakes. They argue broadly instead of proving specifically. A strong response is built on documents, dates, and clauses, not on assumptions. Most demand letters include a deadline, often expressed in working days. That deadline is not always a legal requirement, but it is a strategic timeline the sender may use to justify escalation. You should also consider how the letter was delivered. Even though a demand letter is not a court document, verifiable delivery, such as courier records or official email channels, can help establish proof of notice and timelines. In some contracts, proper notice is also part of the contract's escalation structure. Practically, if you ignore a well-documented letter, you may face a faster move to arbitration or court, with less room to negotiate. After review, there are typically three strategic paths. 1. Engage and explore settlement if liability is likely or if a commercial solution is possible. 2. Dispute the claim with a structured reply supported by contract clauses and documents, especially where the claim is inflated or incorrect. 3. Request clarification and time where facts must be verified, using a carefully framed, professional response that avoids admissions while keeping communication open. The goal is not to write a long letter. The goal is to control tone, protect your legal position, and keep options open. Where settlement discussions are appropriate, keep them professional and clearly separated from factual admissions. Demand letters often contain hints about the sender's next move, references to litigation or arbitration, specific deadlines, and whether they mention interim measures that may be available under law. These signals help you calibrate response speed and strategy. If the other side appears ready to escalate quickly, your best protection is preparation. Organize evidence, confirm who has signing authority on your side, and ensure your response is consistent with your intended defense. In Vietnam disputes, procedural readiness is often what separates manageable risk from expensive surprise. A foreign buyer received a demand letter alleging late payment and breach. Instead of ignoring it, the company prepared a structured response. It documented delivery delays, confirmed partial payments already made, and referenced contract terms tied to acceptance and performance milestones. The tone was firm but professional. The claimant changed course from escalation to negotiation, and the matter was resolved privately through a structured settlement. Details adjusted for confidentiality. The takeaway: the right response can reduce conflict, protect reputation, and avoid unnecessary proceedings. 4 mistakes repeat in Vietnam demand letter scenarios. 1. Ignoring the letter entirely. 2. Replying emotionally without legal review. 3. Making unintended admissions or inconsistent statements. 4. Letting junior staff or sales teams respond informally. Demand letters can become part of the dispute record. Mishandling them weakens your negotiation leverage and can complicate your defense if the matter escalates. If your company receives a demand letter in Vietnam, treat it seriously, but respond strategically. LTS law can help you assess exposure, prepare a legally disciplined response, and choose the best next step, whether that is settlement or defense. Visit lts.com.vn for a confidential consultation. Because in Vietnam, how you respond early often shapes how the dispute ends.